Welcome to Family Law A to Z with DBD.
Welcome to Family Law A to Z with DBD, a podcast from the Pennsylvania-based firm Dischel, Bartle, Dooley. This series reflects the collective experience of a firm's family law team, including attorneys Mark Dischel, Elizabeth Billies, and Katie Lin Daly, who work closely together to provide clear, practical guidance on the legal issues that impact your family and your future. I'm Lisa Mosbey, and today we're talking about protection from the abuse orders in Pennsylvania, what they are, how they work, and what people should understand about the process. Joining me for this conversation is attorney Katie Lin Daly. Katie Lin focuses exclusively on family law and regularly handles custody, support, and protection from abuse matters. She approaches these cases with care, clarity, and a steady focus on helping clients understand their options. Katie Lin, it's great to have you on the show. Thank you so much for joining me.
Thanks for having me, Lisa.
To start, could you explain what a protection from abuse order is under Pennsylvania law?
So a PFA order is an order that is entered under the Protection from Abuse Act. The purpose of the act is to protect plaintiffs, the people who file these petitions, from defendants, people who were accused of having abused or harmed the plaintiffs in some way. A PFA is an order that is signed by a judge that generally will preclude the defendant from speaking with the plaintiff, from communicating with the plaintiff, from harassing, stalking, abusing the plaintiff. It can evict the defendant from the plaintiff's home. It can set forth a temporary custody order. It can allocate fees due from the defendant to the plaintiff, and it can require the defendant to give up the access to any access that they have to firearms for the duration of the order. It's a court order. It's a civil court order. It's not a criminal conviction. And the whole purpose is really to protect plaintiffs.
And then, Katie Lin, who is eligible to seek a PFA in Pennsylvania? And are there specific relationship requirements?
There absolutely are. So in order to be a plaintiff under a PFA petition, there's two prongs. So the first prong is the relationship, what you just mentioned. So you need to have some sort of familial, domestic, intimate partner relationship with the defendant. That can be parents, children, siblings, grandparents, intimate partners, boyfriend, girlfriend, dating. I guess we could even line that out to situationships, to use today's language. But you have to have that specific relationship with the defendant. Roommates are actually also included under the language of the statute. But you can't, willy-nilly go and file a PFA against a coworker who you don't have that relationship with, or a friend who you don't have that relationship with. It's a pretty narrow pool of people who are eligible to be the defendant in your PFA petition. The other prong of a PFA petition is that there has to have been some abuse suffered. And there's really 5 different definitions of what abuse is. Your first definition is going to be actually causing or attempting to cause severe bodily injury. That can be, a punch in the face, that can be a strangulation, that can be hitting someone with your car. That's, actual physical harm done to the plaintiff. And then we have the definition that's the putting the plaintiff in reasonable fear of that type of harm. So maybe you as the plaintiff aren't actually getting hit, but the defendant is cocking their fist at you or making a threat to cock their fist at you. Then we have false imprisonment. That's where the defendant is preventing the plaintiff from leaving a place where they would like to leave. That can include holding car keys. You can't leave this room because I have your car keys. Or it could even be, the plaintiff closes themselves in a room because they're so frightened. The fourth prong would be the sexual abuse of children. I think that kind of, goes without saying. And then the fifth definition is what we call a course of conduct, which is what, in the common language you might think of as stalking. Someone who is following you around, someone who is showing up where you don't think that they're expected to be. And that course of conduct puts the plaintiff in fear.
And then what's the difference between a temporary PFA and a final PFA?
So to answer that question, I'll get a little bit into the procedure. So if you're a plaintiff and you want to file a PFA action, if it is, normal business hours, it's within 9 to 5, you would go to your county courthouse, you would file a PFA with the prothonotary, and then you would go to what's called an ex parte hearing. Ex parte just means it's a one-sided hearing. It's the plaintiff and the judge. The defendant is not present. At that hearing, the judge will have read the PFA petition where the plaintiff, set forth what actually happened in terms of abuse. And the judge will have the opportunity to ask the plaintiff questions. What happened? When did it happen? What is there a proper relationship? Was there police intervention? Was there medical treatment necessary? Things like that. So after that ex parte hearing, if the judge feels that there is a clear risk of harm to the plaintiff, they can enter a temporary PFA order. So a temporary PFA order is not after a full-blown hearing. It's after only the plaintiff has filed a petition and the judge has heard from the plaintiff. Temporary PFAs initially usually last about 10 days until the date of the final PFA hearing. Now, there's some nuance in this because the final PFA hearing might not actually happen within those 10 days. There can be continuances for either party to get an attorney. There can be continuances because there's criminal charges pending. There can be continuances just because of, the court schedule and the party schedule, things like that. So a temporary PFA is, temporary in nature until a final hearing. A final PFA is granted in two situations. The first is if the defendant fails to appear for the PFA hearing, even though they've been served. So, little tangent on that. After the plaintiff files the PFA and receives the temporary PFA order, the defendant is served either by the sheriff or by the police. So they'll receive a whole packet of information that includes the PFA petition, the temporary order, the order scheduling the hearing, all of that information. If the defendant has that packet of information, is aware of the fact that a hearing has been scheduled, and does not appear for that hearing, the plaintiff can request that the court enter a final PFA by default. So that's the first way to get a final order. Defendant knows about the hearing and they fail to appear. The second way to get a final PFA is to have a hearing, to have the plaintiff testify, to potentially have witnesses testify, to have the defendant testify, to put on evidence, and only after that final hearing can the judge say, this rises to the level of abuse that is protected under the statute, and I'm going to enter a final PFA order. A final PFA order can last for 3 years. Now, if at the end of the 3-year period, there's still behavior going on that leads the plaintiff to continue to be in fear, there can be a continuation of that final order. But generally, a temporary PFA is going to last between 10 days and let's call it 6 months, just to have a nice little number on it. And a final PFA is going to last for up to 3 years.
And Katie Lin, how does a PFA interact with custody or support matters that may already be pending?
Your PFA, if there are minor children involved, one of the paragraphs in the petition and in the order references custody. So oftentimes what I find is that a PFA predates any custody or support issues because they usually predate the separation of the parents. If the parents are living together and there's abuse going on, the abuse happens, the parents separate. So generally, not always, but generally, at the time that a PFA is filed, there is no custody order in place. There is no support order in place. If the parents are married, there's usually no divorce pending. So in a PFA, a temporary or a final PFA can include custody provisions. It can include things like what is the actual custody schedule. It can include how the parents are to communicate about the children, because that's very important. When a PFA says mom and dad can't talk to each other, but we have to make decisions about the kids, that's a huge issue in terms of how are decisions being made? Are they being made in the best interest of the kids? Things like that. So a temporary PFA can include custody terms. What the courts have been doing lately, in my experience, is counseling plaintiffs who file PFAs to immediately file a custody action simultaneous with the filing of the PFA. The reason that they need to do this is because PFA courts are about adjudicating findings of abuse, and custody courts are about the determination of the best interests of the children. It's a Venn diagram, but it's not a perfect intersection. So a temporary PFA might say that the best interest of the children is to be with the plaintiff and to not be abused, whereas long-term, the best interest of the children is to have both parents in their life in a safe and meaningful way. Now, in terms of support, there is a paragraph in a temporary PFA order that says that the defendant is liable to the plaintiff for support for the plaintiff and the minor children. In my experience in working in family law, I have not seen a temporary or even a final PFA order that's actually giving a number of the support payment per month, because similar to custody, the domestic relations section is the one who's doing the math on the support, not the PFA court. The PFA judge is not going to pull up a support calculator and figure out everybody's income and run guidelines. The PFA judge's goal is just to keep the plaintiff safe. They're not getting into the little nuances of, does somebody have Wednesday overnight or Thursday overnight, or are the parties going to file their taxes jointly, and what impact that has on a support number. In a PFA order, the courts are very hesitant to include ancillary claims that are not related to the strict findings of abuse.
And what are the consequences if a PFA order is violated?
There can be some pretty severe consequences if a PFA order is violated. If a plaintiff notifies the police or files a petition for contempt alleging that the defendant has violated the PFA order, there is what's called an indirect criminal contempt, an ICC. That is a hearing before the PFA judge. It's not a criminal proceeding. It is still a civil proceeding. But the consequences can include up to 6 months of incarceration. And it's very important, if you're the defendant in a PFA matter, to understand the terms of your order, to understand what you are and what you are not allowed to do under the order. What I see oftentimes is in cases where there are children and the parties do need to communicate about the children, communicating about the children is not a violation of the PFA most of the time. But communicating with the plaintiff ostensibly about the children in a way that's not actually about the children, that can be a violation. The other thing I usually tell when I represent the defendant in a PFA matter is, even if the plaintiff reaches out to you and asks you a question that's not about the children, or asks to have a conversation with you, asks to speak with you, anything like that, even if they are the one reaching out, when you're the defendant and you're bound by the terms of a PFA order, you should not be responding to the plaintiff, even though they're the one who reached out. You can still be found in contempt, even if the plaintiff initiated the contact.
Katie Lin, where I'd like to wrap this up today is for someone considering filing for a PFA or responding to one, what is the most important thing to understand about the seriousness of this process and the importance of proper representation?
As a plaintiff, the PFA Act makes it relatively easy for a plaintiff to file and to get an ex parte PFA on their own. You go to the prothonotary, they walk you through it, you write out the allegations, you go before the judge. Everyone in the court system is fairly understanding of the fact that people who have gone through abusive situations are, perhaps fragile, perhaps emotional. They need a little bit of help with the situation. So to get an ex parte temporary PFA, it's not necessary to have an attorney. The whole system is kind of oriented to help people in emergency situations get out of that emergency situation very quickly. If you had an altercation with your significant other the night before, and maybe there's police involved, maybe there's medical attention necessary, maybe we have to get the kids to school still, the last thing that you're thinking of is, oh, let me hire an attorney to go to court today. Now, once you have that temporary PFA order, having an attorney there to help you either negotiate the terms of an agreed PFA or to go through the nuances of a whole PFA trial, including, the rules of evidence, presenting witnesses, presenting documentary evidence, things like that. Most plaintiffs aren't going to be equipped to do those things by themselves. And there are plenty of programs available throughout the Commonwealth that will provide attorneys to plaintiffs in PFA matters just because the representation there is so important. Now, the nuance to legal aid situation type of representation is that that attorney is only going to represent you in the PFA. If there is a custody matter or a divorce matter or a support matter that follows the entry of that PFA order, you're going to have a new attorney jump in. And it can be kind of difficult for a new attorney to get acclimated when that attorney isn't handling every aspect of the case. So for a plaintiff, there are attorneys that are available to you. Depending on, the finances of the situation, I usually recommend, if you're going to go through with a custody order or a divorce matter or a support matter, having one attorney handle all of the matters is probably to your benefit. Now, if you're the defendant, those programs are not necessarily going to be available to you because the programs are pointed at protecting plaintiffs, not necessarily defendants. Now, that being said, it is so incredibly important when you, as the defendant, receive that PFA packet from either the sheriff or from the police. It's important that you act quickly to obtain representation. If there is any chance at all that there are companion criminal charges, it's very important that you have either a family law attorney or a criminal attorney represent you in the PFA who understands the consequences of testifying at a PFA hearing when there's criminal charges pending. So I think I had mentioned earlier, PFAs can be continued. You can have a long-term temporary PFA if there's criminal charges that need to be worked out. And the reason why there's a continuance is because the criminal charges are going to take precedent. The criminal charges are going to implicate a liberty interest. And you as the defendant don't want to testify in a PFA matter if your testimony can be used against you in your criminal matter. So it is very important to have an attorney who understands the intersection of your criminal matter and your PFA matter. And then similar to what I mentioned with plaintiffs, having an attorney who is going to handle every aspect of the case moving forward. If it's just a PFA, if there's no children, if there's no divorce, if there's no support, having a criminal attorney handle your PFA is perfectly fine. Now, if you're going to have custody, support, equitable distribution, things like that, having a family law attorney or a criminal attorney and a family law attorney who work well together, that is going to give a defendant, their best case scenario in a PFA matter.
Katie Lin, thank you so much for your insights and your guidance through this complicated process. We appreciate it. And that's it for today's episode of Family Law A to Z with DBD. If you'd like to learn more about Katie Lin Daly or the family law team at Deshelle Bartle Dooley, visit dbdlaw.com for information about protection from abuse matters and other family law services. Thank you for listening, and we invite you to subscribe, leave a review, and share this episode with someone who may find it helpful. We'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.